How can I minimize conflict during probate in the family? Hey there, my name is Ron Payne. I'm an estate planning and probate attorney here in the Kernersville and Piedmont Triad of North Carolina. And we oftentimes see heartbreaking family distrust, acrimony, fighting during the loss of a loved one. And I'm hoping that this video today can give you some tips, especially if you are in the situation of being the designated executor or you're the power of attorney for a loved one. And it's easy to mistrust each other because, siblings are tough and you know all each other's buttons and you know how to push and you also know each other's flaws. You're close to each other. And so it makes it easy to kind of be at each other's throats, especially when something's happened to one of the parents that you love the most. Family is so important. It's so important to the team here at Apple Pen Law. And I hope these tips for you today will provide for you a framework of how to minimize and avoid conflict. So we've got 4 tips for you. So here we go. The first one, maybe it seems obvious, but it's not, because things are so stressful and it's easy for little things to slip by the wayside. And the biggest thing is open communication. Before you ever file anything at the courthouse, communicate with your siblings and just say, this is what's going on. Now, we generally will even advise our clients, if you're picking a child who's not maybe the obvious one to the whole family, to be your executor or to be your power of attorney, have that conversation with the family. No, it's not fun, but you need to have that conversation, because if you tell your kids, I'm picking them because they're closest, they live next door to me, it makes the most sense. Or you can just say, look, I know that all of you would help. I know you guys will work together, but at the end of the day, we got to pick somebody. So I've picked this person. I just want you to know it from me. And it would allow them to, have a open and honest conversation. Now, if you're the kind of family where you don't discuss finances and you don't discuss serious topics, this is probably not the one you want to start with, but you want to have these open and honest and serious conversations about what your wishes are, so that when it comes time to tell them what you're thinking or who you've put in charge, you don't want it to come as a surprise. And then the other part of that is, once you've told them that and, once you've passed, and if you're the executor, you need to keep everybody updated. Now, probate, especially in North Carolina, but everywhere probably, I don't know, it moves so slowly. And so you need to keep people apprised, even if the update is nothing's going on. The first 30 days when you file for probate in North Carolina kind of moves quickly, because you're getting, you're waiting for it to come back from the clerk of court, you're gathering everything, and you're getting it submitted and turned in. And then for the next 60 to 90 days, you're waiting on the notice to creditors run. You're just waiting for the mail to come in. You're waiting for those bills. You're gathering assets. So you don't really have a ton of updates. You're going to the bank and you're doing all these things. So it looks like you're busy, but then you're not keeping people posted because nothing's happening. You're just getting everything together. If you can send out a bi-weekly, a monthly update, hey, I went to the bank this week, I'm gathering all of the assets, I took the checking account that had mom's name on it and I've moved it to the estate checking account. This is the one that's going to be supervised and monitored by the clerk of court. They're going to audit it so you guys can know that I'm not going to take anything that's not appropriate. If you're letting them know you're just moving the money from that family account, which was, the decedent's account, and you're moving it to the estate account, you're just moving it because that's what the law requires. Oh, okay. If you don't tell them that, conversely, and they see you moved $200,000 out of mom's checking account, and they don't know you put it in the estate account, it looks to them like you're stealing when you're just doing what you're supposed to do. This is why open communication is so important. I can't emphasize it enough. You've got to do it. Secondly, encourage your family members. Not only does the executor need an attorney, but if you think that they don't trust you, have your own independent attorney. It's okay. Now, maybe it seems counterintuitive. Well, if I tell them to hire a lawyer, they're going to sue me. I mean, maybe, but if you're doing it right and you're being open and transparent about it, they won't be able to remove you as executor and they won't have anything to challenge because you're doing it by the book. This is also why it's so important to have legal counsel on your side. A lot of times, You think, okay, well, I just got to move everything in here and I just pay all the bills. But let's just say there's not quite enough money to pay all the bills. Then if you pay the bills out of order, you're coming out of pocket for that. If you distribute the money incorrectly, or if you distribute the money before you've had a chance to pay all those bills and a valid claims come in, then you're going to have to go to your siblings or your co-beneficiaries, your co-inheritors of the will, and say, hey, I'm going to need that money back. Well, hat tip, it's not coming back, right? You've got to do it right before you spend it. Involve legal counsel. Let us help you, and let your family members get independent counsel as well. That way, they can have somebody, not your attorney, telling them, yeah, this is by the book. This is how it's done. They can look at the 90-day inventory. They can ask clarification questions and give you independent peace of mind. It's being done right. Along with open communication and legal counsel, number 3, having family meetings. Just hold a regular family meeting. Hey, once a month, let's get together. I'll give you all the updates. You could even probably argue that that's an expense of the estate. You're meeting with the beneficiaries to provide them updates. You bought them all dinner at the restaurant. Now, I probably wouldn't want to put that on the estate bill because the clerk of court might go. But, that's money well spent out of the executor's pocket, even if you're saying, look, let's go have dinner, my treat, not using mom and dad's money. I just want you to know that I'm handling this correctly. And give them a chance to ask questions. If there's concerns, if there's disputes, sometimes it's a lot easier to say something ugly and mean in a text message or an email. If they meet with you face to face, it's a little easier for them to look you in the eye and go, okay, I trust you're handling this correctly. The last tip we have for you is you need to also look out for yourself. Whether you're the heir, whether you're an executor, whether you're just a spouse of a family member, grief counseling is so important. Look, probate attorneys, our job is not grief counseling, although we certainly recommend therapy. We certainly recommend counseling. It is so helpful. But family therapy sessions can help, doing it as a group, or just having a chance to process your own grief. Many times we'll see an executor come in and they're not ready to process that grief. They've been so busy handling the work of the estate, and they don't have a chance to process their own grief. So you really want to take the chance to sit down and appreciate the life of your loved one, and take a chance to process and allow yourself to feel those big emotions that you're going to feel. Allow yourself to feel the loss, to feel grief, to feel sympathy, to feel empathy, and to allow yourself to also recognize that your spouse, your siblings, maybe your other parent, if they're still here, are also feeling every one of these emotions. Take time to just allow those feelings to be present. We are who we are because we feel those emotions, because we feel those connections. We mourn the lost connection with a parent, with a sibling, with a loved one, with a child. And it's so important to just take the time to feel that and to recognize it for what it is. Because if you don't recognize that, it's going to be there and it will bubble up when you least expect it, and probably not at a convenient time. Take the time to have those feelings. So, in order to minimize conflict, have great open communication, involve qualified legal counsel, have family meetings, get counseling, and by doing all of these things, you'll be able to minimize that family conflict. It'll preserve your relationships with your family and allow for the maximum amount of the estate to be sent to the families, and minimize conflict within the estate, minimize those legal fees, and promote an efficient and quicker, it won't be quick, it's working with the state, but the efficient execution of the probate estate. Families can navigate this challenging time with understanding and unity. If the team here at Apple Payne Law can help you navigate life's important decisions down that road of grief and probate, we are here to help. Reach out to us on the web at applepaynelaw.com or give us a call at 336-281-6928. You can access our free resources on our website, including an after-death guide that allows you to put all that information in one quick place. And that way that's something you can distribute easily to the rest of the family, or to set up a consultation if you need to talk to us, whether you're the executor and you want to know how to best proceed, or you're an heir and you just want insight into what's going on with your family member's estate. We are here to help. Until next time, stay safe, know that you are loved, take care, and have a great day.